next matter to come before the court this morning is Ohio Bell Telephone versus Eclipse Companies. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve that time, if you let me know when you get started, I'm keeping the clock and we'll keep you apprised of the passage of time. The court's read the briefs and we are ready to see when you are.
Thank you. Good morning, and may it please the court. My name is Brian Burketti. I'm counsel for Ohio Bell Telephone, previously plaintiff, now the appellant. And Your Honor, before I begin, and with the permission of the court, I would like to reserve 3 minutes of time for rebuttal. Your Honors, this does not amount to a very complex, this appeal does not amount to a very complex legal argument, or it's not born from a very convoluted fact pattern. Essentially, the limited testimony and evidence that the trial court had since this summary judgment was granted before trial boils down to two competing affidavits. And those were attached to my appellant brief as in the appendixes A2 and A3. Affidavit A2 was an affidavit attached to Ohio Bell's response to Eclipse's request for summary judgment. It is an affidavit signed by Jason Huth, who is an independent third party. He's not employed by Ohio Bell Telephone. He's not employed by Eclipse Companies. He's employed by a company called RPJ, which is a construction management firm. And RPJ was hired by the Akron Public Schools to oversee this project from which this conflict arises. There was some work being done on Akron Oakville High School property. Mr. Huth, as he appears in his affidavit, was the project manager, and as such, he has intimate and extensive knowledge of the projects, the contractors, what's going on where on the project. He swears in his affidavit that on the day in question, the day that Ohio Bell Telephone's facilities were damaged, that the only contractor working in the area in which it occurred was Eclipse Companies. He further goes on to state that based on his knowledge of the project, he is confident, or he does feel, that Eclipse was the party that damaged Ohio Bell's facilities. In a reply to that response submitted by Ohio Bell, Eclipse submitted an affidavit with their reply brief from Matt Sexton, who I believe is the foreman at the time for Eclipse. This affidavit continued to deny Eclipse's involvement with any damaging of Ohio Bell Telephone's property. It is essentially a continuation of the answer where everything was denied. No new parties.
Were there more facts regarding whether or not they had damaged any property?
Thank you, Your Honor. They do indicate that they were contracted to remove 2 poles. I do not believe, or the affidavit goes on to say they did not damage any Ohio Bell property. So it's I guess instead of just denying, it's another affirmative statement saying we didn't do this. But it does not point to another contractor that was there and said, it's not Eclipse, it was contractor A that did this. So what we are left with are 2 affidavits that at their very face are competitive. And they're disputing one of the most material elements of negligence: who did this, who breached their duty. On one side, we have someone with intimate knowledge saying Eclipse did it, and on the other side, we have Eclipse saying we didn't do it.
But is the person who filed the affidavit, the project manager, really saying Eclipse did it? Basically, it seems that he's saying that to his knowledge, no one else was on the construction site, presumably during the hours that he was there. Is that necessarily inconsistent with Eclipse's affidavit saying we were there, but we didn't do it?
Your Honor, I don't know if that. I do feel that there still exists a conflict between the facts of who did it. We do have him, and I do believe his statement was, it is my belief that Eclipse did this.
Well, I thought he said that they were responsible, which would have been really not so much a statement of fact as drawing a legal conclusion, which we really don't consider.
Sure, I do respect that, absolutely. I guess to that point, whether or not his testimony is credible, or to what weight should be given to his knowledge of this project, should really be a matter for the trier of fact. And that's what we would have liked to have seen happen in this case, where Mr. Hughes was able to take the stand, listen to what his actual knowledge was, and then there was additional testimony or additional evidence submitted to the record. One individual was deposed in this. His name was Aaron Gonzalez. He was an employee of Ohio Bell Telephone. I do believe the trial court did receive a transcript of that deposition. Now, Mr. Gonzalez does say he does not know, he does not witness what happened. He does not know exactly who cut down the pole and removed these underground wires. What he can testify to and what his testimony does to bolster Mr. Hughes' affidavit, he knows the time frame when this must have occurred. He knows the type of damage that happened to it. He spoke about in his deposition the fact that the pole, when he got to the damage site, it was a fenced-in area. He was able to enter the fenced-in area. I mean, we can't dispute that. No one was on the site when he arrived in the early evening. Pole was on the ground, and wires were found mangled on the ground, and they were in tracks that appeared to be caused by construction equipment. So when you add that we know a time frame, we know, or we can assume the type of damage, and we have this individual saying, I know the only party out there was Eclipse. When this is all added together, all circumstantial, but definitely a jury or a trier of fact can weigh everything they heard at trial and then make the ultimate decision. I guess what Ohio Bell Telephone is essentially objecting to is whether or not we met that very minimum standard of surviving summary judgment. You know, as it's well established, in reviewing that, a trial court should view it in a light most favorable to the non-moving party, which in this case was Ohio Bell Telephone. And we do feel that when you view those affidavits in the light most favorable to Ohio Bell, that there is a requisite conflict or dispute over who did it. And we do feel for that reason, or we are requesting that this court consider remanding this back to the trial court for trial. On a secondary note, the trial court also discussed res ipsa loquitur in their decision to grant summary judgment. As the court is aware, res ipsa is an alternative way to establish negligence. Ohio Bell Telephone never requested that the trial court kind of grant or give it this ability to allow the trier of fact to infer negligence occurred here. We don't really feel that this is the kind of case in which this doctrine is I guess, appropriate. And the fact that the trial court used this, that test in deciding to grant summary judgment was error. I believe in their order, the judgment entry granting it, they talked about Ohio Bell not being able to prove exclusivity of control over the instrument that caused the damage, which is a res ipsa doctrine requisite, but it's not appropriate in a case like this.
So my question, and after reading the briefs, was whether or not the trial court actually analyzed in the alternative. In other words, considered this on a negligence theory and then in the alternative under res ipsa loquitur. And if that's the case, what would be the error in considering alternative theories, whether or not Ohio Bell asked the court to do so?
Sure. Thank you. And I don't think that would necessarily be error if they did both of those analyses. I do, from my reading of the judgment entry, and it may have just been not clear to me, I do not feel that they did that, or at least it doesn't appear that they did that. It looked like they relied on the res ipsa without really addressing the negligence. I do know that they speak about the elements of negligence and then go into the kind of the affidavits and then go right into the res ipsa analysis. But to me, it appeared that the court relied too heavily on res ipsa as opposed to just looking at it from a negligence standpoint. And our last kind of reason for appeal was this issue of trespass. Ohio Bell brought suit under both negligence and a trespass cause of action, alleging that the contractor entered into its real property or real fixtures, to it the underground wires as well as the fixed telephone pole. The trial court dismissed it, and we felt two reasons for that. Number one, we still feel there's a conflict over whether or not Eclipse did it. We still have the affidavit saying they were the company responsible, and we still have Eclipse saying they did not do it. But secondly, the trial court spoke upon the element of intentional. They indicated that the affidavit by Eclipse indicated that we did not do anything, we did not damage these facilities, so they did not intend to do anything. And that was their definition of intention. We would contend that intentional means intending to do the act. In this case, it would be excavating, and that excavating is if it enters into land they did not have permission to enter into, that would be the trespass. It's not whether they intended to strike the pole or strike the wires, it's whether or not they intended to do the act that caused that damage or caused that entry.
Was there a disputed question of fact as to whether or not Eclipse moved the poles? I mean, they said that they were there,
Sure.
they were contracted to move the poles. But was there a disputed issue of fact as to whether they did so?
To be truthful, Your Honor, into the record that the trial court had, I'm not sure if that was clearly flushed out at this point.
Okay. Because it seems to me that even if they moved the pole, and if there's no dispute as to whether they moved the pole, there could be a dispute as to whether they damaged the cable. Someone else could have moved the pole.
Correct.
Thank you.
Thank you. And if there are no further questions, I don't believe I have any further argument at this point. Thank you.
Good morning, may it please the court, counsel. My name is Alan Glassman. I have the privilege of representing Eclipse in this matter. By way of theories, we have two theories here. The first is a negligence theory, and the second is a trespass theory. Initially, I want to address the negligence theory. I don't think there is any dispute on the basic Hornbook type law. The plaintiff must establish a duty and then a breach of duty. What we're here and talking about in this negligence theory this morning so far is whether plaintiff, the appellant, has established the breach of duty. In its summary judgment, Eclipse came up with direct affirmative evidence that indicated that they did not remove the wires or the fiber cables in this particular case. They didn't know who did it. They didn't instruct anybody to do this. Let me digress for a minute and answer your question about pole removal. Sometime after this all happened, the poles were ultimately removed, but not at the point in time where this event took place. My client had an obligation under its contract to remove the poles. They didn't believe they had any obligation to remove the fibers or the wire cables, and they take the position, as indicated in the affidavit, that they didn't do it.
Didn't do what?
Did not remove the cables, etc. They believed their obligation was, after all this was done, the cables were detached and removed, they were then under their contract obligated to remove just the poles. So at some point these cables and wires got detached. My client, again, maintains by way of affidavit that they didn't do it. Sometime later, after this all happened, they complied with their contract. Okay, but it wasn't during the sequence of events here that are critical to this appeal. Does that answer the question? I want to make sure you have an answer. Let's go back then to the fact pattern. They have set forth the fact that they did not remove the wires. They did not know who did it, and they didn't instruct anybody to do it. Plaintiff responds with their affidavit, which is more conclusions and speculations that they believe Eclipse did it. They have no direct evidence that they did it. It's mere speculation. They don't use the word, well, we want to draw an inference of negligence on a theory of res ipsa, but it's a form over substance argument, because the affidavit from Mr. Huth is essentially res ipsa. They're basically saying Eclipse was in exclusive control, therefore nobody else could have done it. That's what res ipsa is. But it indicated in the reply briefs there was not exclusive control. There were other contractors there, including electrical contractors who had access to this project site. Mr. Gonzalez, who came to do these repairs at night after the call came in that there was apparently some damage, he said in his affidavit, his deposition testimony, I apologize, he came there at night. No one was working, and he gained access to this construction site. There's no exclusive control. Hypothetically, vandals could have done it. But what we're engaging here is a lot of speculation by the plaintiff that my client did it, but no affirmative evidence to rebut that. Again, just a lot of speculation, all based on exclusive control. Mr. Gonzalez comes up with, again, this theory, again, of exclusive control, that he sees some tracks in the ground. And therefore, ipso facto, it's Eclipse. Well, there's no evidence of where these tracks came from, who these tracks belong to, how they got there. It could have come from anybody at any point. Again, it's all based on this theory that my client had exclusive control, when that's not the fact.
Well, what is it that Eclipse said that it was doing at the site on the day in question?
They were working on other aspects of their job. Okay, they had
They were working on other
Yes,
things?
they were on the project site that day. Okay, I don't remember, to be quite candid, exactly what job they were doing that day. This was a project, an ongoing project to redevelop the learning center there. But they said they did not remove the poles that day. They didn't instruct anybody to do it, and they don't know who did.
But does it matter? Is the damage the detachment of the wires, or is the damage to the actual fiber wires themselves that the plaintiff is claiming?
Would you ask your question again, Your Honor? I want to make sure I understood it.
Their testimony that they did not remove the poles while they were there that day.
Okay.
Is that where the analysis ends? Because isn't the allegation that the damage done to the wires may or may not have been related to detaching the wires from the poles or the moving of the poles?
Your Honor, I think their testimony is they did not remove the wires.
Okay, so I think that's what I agree that that's what the affidavit says. We didn't detach the wires from the poles that day, or that they didn't believe that they detached them.
Okay.
In other words, that may have been part of our job. We're not saying it was, okay.
They're saying it was not at all part of it.
It's not something we did while we were out there. The claim is that we have some wires, mangled wires, in some tire tracks.
That's not the whole claim, I think. I think the claim, if you read Mr. Gonzalez's depo testimony, is that these wires, if you imagine old-fashioned telephone poles, they have wires that run across them. Okay? Mr. Gonzalez is saying that those wires that were attached to the poles, when he got there that night, they were detached and on the ground mangled. And it's the detachment from the pole that causes the cable service and all the things that were provided to go out. And that's what gets him to the site.
Am I correct, though, that the poles, Eclipse did remove the poles from the ground that day, they just didn't remove them from the site that day, is that correct?
At some point, they did remove them from the ground.
That day?
No, not that day. Sometime down the road. I don't even know what day they removed the poles.
It doesn't say they're either in the affidavit.
No, it doesn't. I don't know that the day that they remove them is critical to the analysis.
But it's sometime, you're saying it's sometime after the fact of this damage was discovered.
Well,
Is when Eclipse removed the pole.
at some time down the road, these poles were removed. That was their obligation. Okay, I didn't go into the day they did it because I don't know that it has been critical to the analysis of the facts here.
It's hard to tell from the affidavit, because it says as part of the work being performed, they were to remove 2 telephone poles. Then it says, before the poles were removed, I observed the cables that had been attached to the poles were on the ground. Okay. There's no, I'm not getting from this affidavit where the poles, it's unclear from the affidavit when all this stuff occurred, okay? It's unclear, I don't see it here.
Okay.
You were supposed to remove the poles, you noticed the poles were there and the cable wasn't attached on that day, but it's unclear to me what happened that day when somebody, when it was Mr. Sexton, observed the wires and cables that had been attached to the poles were now on the ground. It's very unclear to me what exactly transpired and what time frame, according to this affidavit. I can't tell.
Okay.
Can you clarify any better?
I can tell you that, no, I can't, in the sense that the poles I know were not removed on the day that Ohio Bell came out claiming that my client damaged it. Okay? We were on the site that day and we observed the wires on the ground. That's the best I can tell you. At this point, I don't know that anybody has been looking at this from the day the poles were removed as being critical to the analysis, and I apologize if that's where you're looking at it from, and I apologize if we didn't meet eye to eye on that.
Well, I don't think any apology is needed. It's just that where there are inferences that are to be drawn, number one, we can only look at what's in the record, and the record are, the affidavits in support of, and the deposition testimony, and those inferences are to be drawn in favor of the non-moving party. So.
And I certainly understand that, but from the inference we're looking here is that the poles were in the ground when the gentleman, Mr. Gonzalez, from Ohio Bell, comes there that night. The poles are in the ground. So from the analysis and the inference, I don't necessarily, believe that when the poles are ultimately removed after that is critical to the analysis. The Ohio Bell representatives are saying, we got there, these wires are down, you must have taken them down. My client is saying, we never took them down at any point in time. We didn't instruct anybody to take them down at any point in time. Okay? And that's essentially it. So there is no question that the poles were still in the ground when the gentleman from Ohio Bell came there on June 5th, 2013. The exclusive control issue is where, again, the plaintiff comes back and says, you must have done it because you're the only one on site that would have taken these wires off.
Not necessarily alleging that they were taken off on purpose by someone's knowing act. Perhaps they were inadvertently detached from the poles, ended up on the ground, and no one noticed. Because I'm getting that the element of damage is not the fact that they became detached is why the Ohio Bell person came out that night. Service was discontinued at that point. But I'm not getting the feeling that's the sum total of the damage. Now we have the mangled wires on the ground. There's obviously some damage to the wires, maybe not just the interruption of service or the time involved in coming out there to check out what was wrong. I don't know, we have the affidavits in front of us, we don't have the deposition testimony, and we don't have the actual complaint to the extent that it specifies all the elements of damage. But we have before the court on a motion for summary judgment the defendant's assertion that they did not do anything related to those poles. Which doesn't mean a whole lot, does it, if something happened inadvertently?
I guess let's assume for the moment it happens inadvertently. It's still up to the plaintiff to show that it was my client that did the act, that committed this inadvertent act to cause the damage. And I don't believe the plaintiff has shown any evidence that that has happened other than speculation. And I think that's where I'm coming from here. And plaintiff has not shown that my client did any of these acts, whether they were intentional or inadvertent, other than to say, you were the only one that had access there. And that's not true. I think my time is up.
Just about.
Thank you.
Thank you. Counsel, you have just over 3 minutes remaining for the...
Thank you, Your Honors. And I'm not quite sure I'll use that full 3 minutes either. Clearly, there was a lot of testimony that still needed to be flushed out in this case. Truthfully, both affidavits are probably lacking in some critical details that would have been helpful probably to the trial court and to this court. Just narrowing it back down to it though, whether or not there still disputes a material fact, Ohio still believes that that fact does exist, who did it. We do feel there's credible testimony by Mr. Hughes in his affidavit that Eclipse did do it. He says that they were the only contractor on that site on that time. There was damage to the wires, the mega wires. If Eclipse noticed that the wires were on the ground, but I don't want to get into hypotheticals and facts.
Is there a dispute of fact as to who was on the site the day that the damage occurred, the day that the wires were detached from the poles? Is there a dispute of fact regarding who was there before the trial court?
The only dispute I would notice, now that Eclipse is saying we were on the site that day, we just didn't do it, I would say there's not necessarily a dispute in that Mr. Hughes is saying that Eclipse was the only contractor on the site. Eclipse is suggesting that maybe there were other contractors on the site, electrical contractors or something of that nature. So I guess there is a dispute as to who was the only contractor, so who were the contractors on the site. But there's also a dispute as to whether Eclipse breached the duty. They're saying they did not do anything to these AT&T wires. We're suggesting they did. And if there's no further questions, I would... I'm sorry, yes.
You're suggesting they did because they must have, because they were the only people there that day?
Besides that, so we're saying we have a pretty firm ability to say that the loss of service happened at this time, late afternoon. Our individual was going around the area. They can't pinpoint to the exact location where the wires are that caused the loss of service. They know that this area is out, so they're going around and looking. I believe he arrived at the site in the early evening. It was a fenced-in site, but he was able to gain access to it. And in that time, he saw that the wires were damaged, not just removed from the pole, but damaged. I believe the word was mangled. And they were in tracks of construction equipment. Did he see construction equipment there? Did he witness a construction company on site? No, everyone had gone home for the day. But that circumstantial piece of evidence that there's mangled wires in construction tracks and Eclipse was contracted to do work on this area on that day, we believe would be enough. And again, testimony at trial would be much more telling than these two affidavits. We do feel we met the minimum standard. We don't have to show and prove our case in finality in order to survive a summary judgment. We certainly did not do that, but we do feel we at least met the minimum standard to move forward to trial.
I don't understand how, based on what you just articulated, that you say you have a problem with res ipsa loquitur. just based on what you've articulated, your position is, nobody saw us there, you know, no one saw us do anything. Yes, we might have been there, but, you know, it just seems to me that that was an appropriate analysis. It may not have been the only one, but...
And again, I guess to your point, it may be an appropriate analysis at some point, and maybe it's not necessarily reason to grant, appeal and remand it, especially if they did the other analysis.
Mm-hmm.
I guess when I first composed the appeal, my understanding was they didn't even consider negligence. They just went to this higher ability for. I see res ipsa as an opportunity for the plaintiff to kind of skirt a couple steps or to get an inference of negligence when they haven't been able or are not able to prove every single element. So it's a higher, I guess, award or reward for the plaintiff. And we weren't seeking that. We were saying that, allow us to advance under the theory of negligence. It's the harder thing for us to prove. We must show every element, and that's what we wanted. And we felt that at the time, the trial court had only looked at it under res ipsa, said, you guys don't deserve this, therefore it's being dismissed.
Now, the court did, and I know we're running out of time, did, I thought, use a phrase in the entry that you have not proven negligence. Am I right about that? Which really is not the standard for summary judgment, but rather whether or not there is a genuine issue of material fact.
Correct, Your Honor.
Okay. All right, thank you.
Thank you very much.
Thank you both for your presentations today. The court will take the matter under advisement, issue a written decision, which will be mailed to both sides, as well as posted on our website and the Ohio Supreme Court website. Thank you.